I forgot, did I send out or did I post a checklist of questions on licensing? I think we mentioned it last week. I think we're recording now. Just I'll double check. If I didn't, I'll send it out again. Okay, good morning, everyone. Today we are going to be talking, our lecture is basically in 3 parts. When you look at the syllabus, it says officially that we are discussing international arrangements, and that is divided into a discussion on the United States Patent and Trademark Office, the European Patent Convention, and the United Kingdom Act, and we will be discussing similarities and differences. Then we'll be talking about biodiversity and traditional knowledge, which is very interesting, I think. And then we'll be talking about the South African IP policy, which you've all got a copy of. So the first bit, the discussion of the USPTO, EPO, and UK IPO will just be quick. There's no sort of written. It's not like we're working from Dean and Dyer on this one. I'm just going to chat about them and how they work and you know, the similarities and differences between our office and our legislation. And then biodiversity and traditional knowledge is set out in chapter 8 of Dean and Dyer, but it's only the first couple of pages. It's only part A. We're not going to be talking about traditional knowledge with respect to trademarks, copyright, performance protection, and designs. That we don't go there. We only do it insofar as patents. And then we're going to end off with a discussion of the South African IP policy. And what I think we'll do is we will do the offices and biodiversity, then we'll take a break, 5-10 minute break, and we'll come back and do the IP policy, because the IP policy is deserving of quite a lot of attention. Okay, so I haven't really put any together notes or anything on the USPTO, the EPO, and the UKIPO, because it's really just it's just for your context, really, and that is that you know, every country is sovereign, so every country has the right to grant patents according to the standards that it feels are appropriate, right? So there is a great deal of harmonization around the world relating to each country's intellectual property legal framework, but each country tends to be different, and South African legislation is not identical to anybody else's. There are many similarities, particularly with the UK, but there are also several differences, so they need to be explored. But South Africa, UKIPO, and UKIPO stands for the United Kingdom Intellectual Property Office. And then the EPO stands for the European Patent Office. UKIPO, EPO, and South Africa are very similar, and we'll explore those commonalities in more detail in a moment. But the one that's a bit of an outlier is the USPTO. They definitely march to their own drum. So although they have the same standards, you know, of novelty, inventive step, and things like that, there are many differences in practice before the USPTO that make it difficult and expensive to gain a patent in the United States Patent Office. So how do I, as a patent attorney, as a South African inventor, come before the USPTO? So what would typically happen, it doesn't have to happen like this, but it happens in 90% of the cases, is that a provisional application is filed, be it in South Africa or another country. Within 12 months of the first filing of that provisional application, a PCT application is filed, a Patent Cooperation Treaty, that sits there as a single application with having designated all of the member states of the PCT for 18 months in the international phase, during which it will be searched. We'll get the search report, we'll get a written opinion, and that written opinion will change into an international preliminary report on patentability, an IPRP. And then we're armed with that, and then either 30 or 31 months after the earliest priority date, it now comes time to cement your rights in any of the member states of the PCT. The member states have the right to say whether you are required to enter the national phase in that particular country within 30 months or 31 months. And the United States is a 30-month country, which is to say 30 months on or before the expiry of 30 months from the earliest priority date, you must file your patent application in America. And how you do that is you instruct a US patent attorney, you send him all the documents, and then he files it with the US PTO. Almost all countries require a local address for service, which is to say you must instruct a US patent attorney. I, as a South African patent attorney, cannot act directly in front of the US PTO. Why is that? It's, I think, a number of reasons. Every country has it. South Africa has the same rule. US agents can't act directly before South African Patent Office. Only registered patent attorneys can sign documents that are accepted by the South African Patent Office, etc., etc. And it's exactly the same in the US. There's two reasons for that. First of all, it forces you, I mean, I know US law, but I don't know it inside and out. So it forces me to engage with somebody who technically does know the law inside and out. They will have all passed their qualification exams to become US agents. And so I'm required to use him. Secondly, it gives locals a job, right? Just like requiring foreign associates to instruct me to act before the South African Patent Office gives me something to do. I get to build them and make a living on that basis, and I'm a South African. So obviously it's very much in their interest that South Africans work in South Africa and American attorneys work in America. One of the principal differences about US attorneys is that you have two kinds of patent attorneys in the US: patent agents and patent attorneys. Okay. In South Africa, we only have patent attorneys, which is to say we must be an attorney before you can be a patent attorney. So in South Africa, your qualification regime to be a patent attorney is quite difficult and takes a long time because you need a prescribed undergraduate degree in the sciences. And they're commonly called STEM degrees now. So it would be science, technology, engineering, or medicine. And so, you know, most of us have got bachelors of science, BScs. Several of my colleagues are engineers, mechanical engineers, civil engineers, chemical engineers, metallurgical engineers. We all did science, engineering, technology as our first degree at university. And that is because when you're a patent attorney, you are dealing with technology on a daily basis, right? It's 50% technology, 50% law. So you can't be a patent attorney if you don't know your way around a particular technology. And that means that when you become patent attorneys in South Africa, even with you know, my BSc, there's still a lot of stuff that I don't do. So don't give me an engineering, a mechanical engineering invention. I wouldn't know my way around that because I'm not trained in that technology. And likewise, don't give my mechanical engineer partners a patent application that I work on, which deals with pharmaceuticals or chemicals or methods of extraction of manganese from ore or something. They would be, you know, gibbering idiots when it comes to that kind of technology, even more so than they are anyway. So we become very specialized in what we do. There are, in fact, only about 80 or 85 patent attorneys on the register in South Africa, because it's quite difficult to become one, because you've got to do your undergrad degree. And almost all of us have got at least 4 years of technology. Like I did an honors degree, all the engineers have got 4 years, and many of my partners have got masters, or some have even got PhDs in chemistry or biochemistry or genetics or whatever. So there's a long. Okay, then, so now you finish your undergrad degree, great stuff. Now you go back to the beginning, and now you start your LLB. And that's 4 years, right? So now you've got 4 years of science. Now you've got another 4 years of LLB. And I think the rules have changed since my day, but my understanding is that you can't even begin your articles of clerkship until you have at least finished your LLB these days. So you can only begin your articles of clerkship after 8 years, 4 years of science, 4 years of law. Now you begin your articles of clerkship. When you do your articles, it's a very fraught period in your life because you're extremely busy. Not only are you running around very busy in private practice doing what you're doing, but you're also going to, you're doing the law school, which is required to be an attorney. Is it called PLT? I'm not too sure. You're writing your board exam, which is flippin' difficult, as we all know. I know, you know, I'm chatting to several admitted attorneys now, so we all know how fraught writing your board exam is. Okay, that's difficult enough. But then if you want to be a patent attorney, while you're doing all of that, you're holding down the job, you're doing your law school, you're doing your board exam, you're also writing what's called the institute exams, which was to say exams set by the South African Institute of Intellectual Property Law, that's called SIPL. And you've got your Foundation 1 papers and Foundation 2 papers, and you've got to pass all of those before you can call yourself a patent attorney. So it's extremely rare to be qualified as a patent attorney in South Africa before the age of 30. Okay, so it's a long qualification regime. It's really difficult, and as you might imagine, there's not everybody has a level of enthusiasm for that. Not to mention the fact that many students are under pressure to enter the workforce to start earning a salary sooner rather than later, right? It might be because they've got student loans. I mean, can you imagine 8 years of student loans? I mean, that would just be crippling debt. So the barriers of entry to the profession in South Africa are very high. And I don't think that that's a problem which is being addressed adequately, actually, at any level. Because it's very difficult to recruit into the profession because you've got such a long period of entry and you've got these very high barriers to entry. Those SIPL exams, Foundation 1 and Foundation 2, they are very difficult. There is no doubt about it. There are many, many students who simply don't ever pass them just because they're too hard. They have a pass rate of about 20%. 1 in 5 candidates pass in any given year. So it still very much runs in my blood how stressful it was in my late 20s writing those SIPL exams. Not only because you don't want to fail, nobody wants to fail, you really want to be a patent attorney. You've got these very difficult exams you're passing, but you've also invested almost a decade of your life to get to this point. So not to be able to pass them and then to have to admit defeat and move off into another section, whoa, it really bears heavily. So I have a huge amount of sympathy for the youngsters of today entering into the profession. But it does mean that, with the odd exception, myself included, you have a very high caliber of person who enters the profession. They know what's going on. They really do. They really want to be patent attorneys. They've invested financially. They've invested so many years of their life to get to this point. They're motivated. They want to do right. And so as a result of that, the patent attorneys that we have in South Africa, as a rule, as I say, odd exception here and there, as a rule, extremely talented, extremely hardworking, and just clever people. And as a result, because we have such high standards, it's a double-edged sword. We have very high standards, so it's very difficult to become a patent attorney in South Africa. But when you are a patent attorney in South Africa, you tend to be very good and you know your stuff. And we are very highly regarded, internationally speaking. And I know that I've heard it on multiple occasions, just how well we are considered by our peers in other countries. And there's a lot of practical evidence of this. The fact that even though you're qualified in South Africa, if you wanted to go and work overseas, in Australia, in UK, in America, whatever, you would have to requalify there, right, according to their qualification regime. But there is not a firm that I know of that wouldn't instantly give you a job, because they know that if you're a patent attorney in South Africa, you can rise to the level that they impose on their patent attorneys, no problem. And every South African patent attorney who has gone overseas has made an enormous success of themselves. They quickly requalify in their country of choosing, and they go on to pursue very successful careers. And that's because it is such a rigorous training to get to be a patent attorney in South Africa. So I know it sounds like I'm singing my praises, but I'm just saying that in South Africa, this is a very highly regarded profession, and not only here in the country but also overseas. And there are other countries that have similarly difficult qualification regimes, including the UK and including Europe. To be a chartered patent attorney in the UK is very highly considered. To be a European patent attorney, you've done well. And because there are quite high standards applied to those qualifications as well. But critically, South Africa is one of the few countries in the world that require you to be an attorney and a patent agent, okay, to become a patent attorney, per se, patent attorney. So this is a long way of saying, so in the US, you can be an attorney and pass, I think they don't have LLBs in the US. I think they have what they call JDs, Juris Doctorates or whatever. It's a 4-year law degree like ours. But of course, US law is very, very different to ours because they have federal law and they have state law. And really, I have never really got my head around it. It's very complex. Life's too short. So lots of patent attorneys in the US are, in fact, are attorneys. And then their patent exams are set by the USPTO, and they're quite difficult, but you have to pass those as well, and then you become a patent attorney. So you've got a law degree, you're an admitted attorney, and you've passed the exams as set by the USPTO, and then you call yourself a patent attorney. But they have a second species of practitioner in the US called a patent agent, okay? And they haven't done their law degree. They've just got the STEM undergrad, they've got the technology, and then they skip out the whole LLB, the whole writing the board exam, etc., etc. They just write their USPTO exams, and then they become what's called patent agents, and they can only deal with the patent office. The patent office recognizes them, will accept their signature, etc., etc., but the courts don't because they're not attorneys, right? So there is almost like a slightly second level, but it is an easy way to enter the profession. So the barriers of entry in the USPTO are slightly lower. And so when you engage with US attorneys, you must look to see whether he calls himself a patent attorney, which means he's got the law degree, or a patent agent, which means he can only practice before the USPTO. So, you know, that's just something to bear in mind, that there is that. In the UK, almost none of them have law degrees. So they're not solicitors. Very, very few patent attorneys in the UK are solicitors. It's not required. You just do your undergraduate degree and then you do your exams. Now, interestingly, in the UK, the exams are very, very similar to the South African exams. So in the US, you just do like about a 4-hour paper. It's multiple choice. It's set by the USPTO. It's online, and you know it's just a sausage machine. You just keep going back until you pass it. That's not to say it's not a difficult exam. My understanding is from chatting to my American friends is that it is a very difficult exam. And as we all know, multiple choice questions can be very confusing, and in fact sometimes even more difficult than a straight up discussion or whatever. So I'm taking nothing away from the standard of my American chums, but that's how you do it. In the UK, they have an institute very similar to the South African Institute of Intellectual Property Law. Now, the South African Institute of Intellectual Property Law covers patent attorneys and trademark attorneys and all the guys who practice copyright. It's a one-size-fits-all. In the UK, they have two different institutions. They have what CIPA, which is the Chartered Institute of Patent Attorneys, and then CITMA, I think, which is the Chartered Institute of Trademark Attorneys. Okay, so in the UK, trademark attorneys and patent attorneys are separate. They have their own institutes and they do their own thing. Okay. Interestingly, why is it called chartered? Okay. So here in South Africa, we just call patent attorneys or registered patent attorneys. In the UK, they have two kinds of patent attorneys, just registered patent attorneys. And those are people who are on the register, but they haven't joined CIPA, which is the Chartered Institute of Patent Attorneys. And that's because in the UK, if you're a member of CIPA, you've signed up to their code of conduct and rules, etc., etc. So it's a slightly higher standard than just being a registered patent attorney. And it's because CIPA and CITMA, the equivalent trademark institute, have what's called the Royal Seal, which is to say the Queen has said, you're my guy. So your rules and everything like that, it's got the Royal Seal of approval. We like what you do. So you get to call yourself a chartered patent attorney. So it's called CPA, Chartered Patent Attorney in the UK, and it means you've got a STEM degree and you've passed the exams as set by the Chartered Institute of Patent Attorneys. To be a registered patent attorney, you have to pass those same exams, but you're not a member of CIPA, so you haven't signed up to the extra rules and things which govern how you basically conduct yourself and you submit yourself to the disciplinary proceedings, etc., etc. 99% of UK patent attorneys are members of CIPA, but there are the outliers who say, no, we're not into that. I'm not a royalist. I don't buy into the whole royal seal of approval, etc., etc. But so, and good for them. That's cool. But for me, I was like, hell yeah, I'm signing up to be a chartered patent attorney. So you know, the Queen has seen my name on the list, and she said that's good. I'm happy with him. So it's just an English thing. It's a UK thing, but it's pretty cool at the end of the day that you know, this institute has got the royal charter, and it's the same with accountants, and you know, you can be a chartered accountant in the UK, a chartered engineer or whatever. So it's just this level of sort of, you know, competence which is given to that. So that means that in the UK it's slightly easier to be a patent attorney, but it does mean that what people tend to do then is, in South Africa, because we all know that we've got a 4-year LLB waiting for us after we've done our science degree, we tend to move into that as quickly as possible. So we shy off doing masters, and very, very few PhDs out there. Whereas in the UK, because you don't have that 4-year LLB, a lot of people say, oh, well, I'll just do an extra 2 or 3 years of science. And so there's a lot of doctors, PhDs, who are patent attorneys in the UK. So they've got very good STEM backgrounds. So that's quite interesting. But the exams as set by SEPA are very, very similar to the South African Institute exams, in the sense that they are 2-tiered. You have your foundation level papers, and then you have your advanced level papers, which you do in your second year. There's 6 foundation papers and 4 advanced papers. And again, also very difficult, low pass rates. So South Africa and the UK are very, very similar. Interestingly, the UK sets a paper in their foundation phase which deals with like basic law, like explain the difference between the High Court and the Magistrates Court, what's the role of a prosecutor, etc., etc. Just to give these guys who have never seen the inside of a court, because they've just been in the lab the whole time doing their STEM degrees, just a little bit of idea of how a court works. Whereas, of course, in South Africa, we're all attorneys by definition, so we don't have to do that paper. So we get exempted from that paper. But we do an extra paper, I think, is it engineering, drawing? I can't remember. Anyway, there's 6 in South Africa, 6 in the UK, but they're not identical. And then you go into your final phase paper. So, okay. So just to return back to the US, you've got these 2 kinds of patent attorneys in the US: patent agents, patent attorneys, and they all practice before the US PTO. Now, the US PTO, the United States Patent and Trademark Office, is a massive, massive campus. It used to be based in Washington, D.C. at a place called Diamond City, but I think it's outgrown that now. And now there's all sorts of satellite offices, etc., etc. And it receives millions of applications in a year, you know, many of which are refused. And a lot of US examiners work from home because they simply, there's so many of them that to fit them all in one building, to fit them all on one sort of campus, it would just be, you know, difficult. And they want to recruit them from California and Idaho and Florida and Texas. And so everybody just sits in their home offices and examines patent applications. So how it basically works is, in all examining offices, is that they hire, and when I say thousands, I mean literally thousands of patent examiners. Now, who is a patent examiner? It's somebody who's got some experience in technology, be it chemistry or mechanical engineering or whatever, and then they've got some basic training on patent law as provided by the USPTO. They are not patent attorneys, they're not patent agents, although they're very similar to patent agents because they've got the STEM degree and they know the workings of the USPTO. Okay, they know the patent law. And what happens is, you know, you file your application with the USPTO, and there's a big receiving section there, which, you know, gets everything in. Has he signed his, has he got a right attorney? Has he paid the fee? Has he got the deed of assignment? Is the applicant, okay, all good, you know, from a, or this is the receiving office then write to you to say this document is outstanding, send it here. But at the same time, they take the substantive document, the specification, the drawings, the abstract, and they look at it and they say, oh, it deals with golf balls. Okay, cool. So, and they type in golf balls, and up comes up the list of examiners who are good when it comes to golf balls. Okay, and that is the degree to which they drill down for, you know, specialization. Is, they'll have a dozen guys who all they do all day is golfing patents, right? And then so my application goes to this guy, and so it gets shipped off to him. Hey, John, here's a patent application for you to examine. You're a golf ball expert. And then, we've got guys who come, who are experts in paint, and, even then it'll be aqueous or non-aqueous paints. And so you've got thousands and thousands of guys out there who are specialists in their tiny little areas of technology. And when an application comes in and it fits into that area of technology, it gets diverted to him, and it says, okay, examine this. And so these examiners tend to know their little part of the world, their little part of the technology platform, forwards, backwards, inside and out. Okay, so you're not going to get anything past this guy. He will have seen it before. So not only is he going to go online and do a prior art search for everything that was published before your earliest priority date, the prior art, which we've discussed, but he's also got his own like little stash of patent applications which have come before him over the years. And so he knows it all, right? And you can expect a very thorough examination from him. So it's very, very difficult to actually get a patent in the US because these guys really go for it. Okay, they know their stuff. Okay, I'm not going to stray into the area of opinion, and that is, I do think, and it's certainly been my experience, personal experience, that the US are a little bit xenophobic in their approach to patent examination, which is to say, when they see, oh, this guy's from South Africa, and in particular, man, it's just so annoying, but it's how it goes. I filed a couple of applications for the University of Zululand, right? Or you file for the University of KwaZulu-Natal. The Americans, oh, wow, man, did the Zulus make this invention? That's crazy, and it's like so, I don't know the word, but, condescending from our American friends, but they're quite sort of ignorant as to how we roll in South Africa. But they love it when, we send them an application and it's got the word, Zulu or Fort Hare or something like that. It's so exotic for them. When, you just got to smile and wave and get on with it. But it does mean that, when it comes to the examiner's kind of like, I ain't granting no patent to some Zulu dude, And so they work really hard to try and to just not accept your application. They say it's not novel, it's not inventive, and they go to extraordinary lengths to refuse your application. And this is really contrasted with American applicants who get given a much easier time. And when you think about it, it's not understandable, and it's not excusable, but you know where they're coming from. Where they're saying, look, it's an American inventor, and he's holding this monopoly over fellow Americans. So, good for him. I can kind of live with that. He's going to get the monopoly. The money's going to go to a guy in America. That's something I can live with. But there ain't no way that I'm giving a monopoly to some guy from KwaZulu-Natal in South Africa. He's not holding nothing over Americans, And I'm hitting the Americans with a big stick here. But I've got to be honest. This is what I have experienced in the US, and I know that when I file for these universities, Fort Hare, KwaZulu-Natal, Zululand, I'm going to get a hard time. But when we file for, Anglo or De Beers or something like that, things go a whole lot better. So I think the Americans are a little bit xenophobic. They don't like foreign-based applications. So that's my experience. So how does it work in America? You file your application. It gets examined, you get an examination report in which it's refused. You have the opportunity to reply to that examination report. And then if you don't convince the examiner in that first time, he issues a final report. And a final report is, you've got very limited opportunities to make further amendments or anything. There's a small window to try and, if there's just a little bit of ground to close before you reach agreement with the examiner, you can do that. But once you get a final rejection, your backup is against the wall, and then it's rejected. And then the only way that you can get your application back again is to file a request for continued examination, an RCE, and you basically got to pay your application fees again. So it's very biased against the applicant, right? Because, you know, you get basically one shot to argue. I call it 1.5 because you can sometimes, if there's just a few little matters outstanding, he'll entertain those after he's issued his final office action. But basically, that's it. You know, you've got one bite at the cherry, and then if you want to keep it going, you've got to pay your application fees again. That's hugely expensive. Your application fees are thousands of dollars. And, you know, you look at the exchange rate today, it's over 16 Rand a dollar. So if he charges you $2,000 for a request for continued examination, that's 32,000 Rand. And that's just to the USPTO. You actually have to pay your US attorney even more because he's got to prep the documents and do it all again. And then you've got to pay me something as well, which is a fraction of what these guys are charging. But, you know, a request for examination is easily going to come in at 60, 70,000 Rand. So, you know, I mean, it just becomes hideously expensive to prosecute in the US. And they lever that as well. They know that. So, you know, they do it. And so how it tends to work is the examiners. So the examiners are also not consistent. Like I said, they're xenophobic, and they're also not well supervised because they're working from home. So they don't have their supervisor breathing over their neck saying, what's happening, what's happening. You know, the examiner will just like flick an email to his supervisor. The supervisor is probably supervising a dozen, 2 dozen of these guys. He just gives it a quick thing, says, okay, cool, off we go, that's fine. So, you know, we often get poorly drafted examination reports from the USPTO. They haven't applied themselves, they don't understand the technology, and that's because they're working in a little silo from home. And, you know, they don't have the benefit of peer-to-peer consultation, you know, sticking their head out of the windows, saying to the buddy in the office next door, hey, what do you think about this? Et cetera, and their supervision could be better. So the standard of examination in the US can vary greatly. And as I say, tie that in with a little bit of xenophobia, it all becomes a very expensive, very messy operation to get a US patent. But you know, a lot of people are up for it. But I see increasingly South Africans say, you know what, forget America. It'll bankrupt me to get something there. And, you know, really, at the end of the day, let's just get other countries that are more reasonable, right? So South Africans filing in the US is dropping because it's getting more expensive and it's getting it's always been difficult, and it is. Maybe it's not increasingly difficult, but certainly when you add in the exchange rate, it's getting increasingly difficult. Okay, so that's that. When you get your patent granted in the US, another big difference is, you know, in South Africa, the UK, Europe, you have annual maintenance fees, and I've spoken about this before. So you get your first 3 years free, yay, but then the last 17 years of a 20-year lifespan you have to pay for increasingly. In the US, they have something different. In the US, you pay at 3.5, 7, and 10.5 years, or something. I don't know. They only have 3 or 4. It's very complicated as to how they calculate. I don't know why they don't have annual maintenance fees like the rest of the world. I suppose it's got something why they're not metric and they're still on imperial. They do things their own way in the US. So there are lots of differences. They've also got very forgiving novelty provisions. They don't have absolute novelty like we do. You know, like our Section 25 is very, very clear. Anything that's been made available to the public before the date on which you first filed for your patent application is prior art. Okay. In the US, it's like, no, if you tried it on a commercial scale or whatever for up to a year in the US, you can be excused under certain circumstances. So there's all these little back alleys. So it's important that you do chat to a US examiner because, you know, they know all of that inside and out. Whereas for us, it's like, come on, man, you know, it's black and white. It's either novel or it's not. Whereas in the US, there's lots of back alleys on how to get it through, et cetera, et cetera. Again, biased to US applications where the disclosure has taken place in the US, that kind of thing. The US has opposition, post-grant opposition, and the US also has an appeal against the decision of the examiner. So if he finally says no, instead of filing a request for continued examination, you can file an appeal, which is even more expensive. But in appeal, we have very high success rates on appeals because it goes before 3 or 4 examiners who all get to grips with the invention. So it is a good standard of examination. And often we are successful on appeal, but it just costs an arm and a leg when you're paying in dollars and you're paying your US attorney who is charging $700 an hour. What's $700 an hour? So it's about 11,000 Rand an hour. 11,000 Rand an hour. Sally, even I think, senior counsel, that's probably what senior counsel charge in South Africa. What's that? If you charge 8 hours a day, that's 100,000 a day. I think there's only a handful of SCs in South Africa who are charging 100,000 a day, but I don't know. Maybe I'm a little bit behind. But you can see the kind of money that we're talking about there. So it's not a popular option. Something that I don't like about the US, in fact, you can tell I'm actually quite biased against the US. So to be more accurate to say, another thing I don't like about the US is that their examiners work on a point system, right? So they get a certain amount of points for granting an application. They get a certain amount of points for finally refusing an application. And I don't know what's what, but they've got to get a certain number of points. And I think it's easier for them to refuse rather than to grant. So they're much more biased to refuse applications to get the points rather than to grant applications, because I think it takes longer to grant an application. So you spend more time for either the same or maybe even less points. So there's a natural bias in the system to refuse. And there's a very cool website where you can actually type in the name of an examiner and see of all the applications before him, what's his grant rate and what's his refusal rate. And some of them can be really, really biased. So, there's a lack of objectivity in the USPTO. There's a worrying sense of xenophobia, and there's a capacity competency issue with their examiners as well. So, don't ever tell an American that, my word, you can kiss the next 2 hours of your life goodbye as he waxes lyrical about how that's simply not true, etc., etc. But I can say, me, John McKnight, prosecuting applications before the USPTO, that's been my personal experience. So anyway, not a big fan of the USPTO. Let's move on. Let's talk about the EPO, okay? Because the EPO, in my opinion, is a bastion of international best practice when it comes to patent applications. The EPO is simply fantastic, okay? So, and here's why. So the EPO was established, the European Patent Convention was established in the 1970s. And what it basically said on a core level was to all the European countries who, and this is a very important point, don't have to be a member of the European Union. This sits apart from the European Union, okay? So, but any country which is on the European sort of continent per se can join the European Patent Convention, whether or not they're members of the European Union. So, for example, the UK has been a long-standing member of the European Patent Convention. They got in at the ground floor. But when they exited the European Union a couple of years ago through Brexit, it didn't change their membership of the EPC. And there are many countries who are members of the EPC that are not members of the European Union, like, for example, Switzerland is another example, and there's a few others. So it's the first thing to understand is that the EPC is separate from the European Union. You don't have to be a member of the European Union to be a member of the EPC. But if you sign up to the EPC, this is what you say. You say, okay, I've got my national patent system, and that's all cool. So people can still file with me directly, in France or whatever. And I'll do. I've got my own little French patent office here, and we'll do our thing. But also, we're going to establish a central office, a European patent office. And if an applicant files a patent application there and designates France as a country, and the European Patent Office examines that patent application and says it's good to go, and then that applicant wants to come and bring that European patent into France, we sign up for it. Okay. So basically, what everybody says is, although they retain their sovereignty to accept applications nationally, actually, if the European Patent Office says grants a patent, then we will accept that as a granted patent in our country as well, which is very cool, right? That's a great idea. So how it basically works in practice is that a European Patent Office was established, and it was initially established in Munich, and they have got a beautiful campus there, like all these wonderful buildings just next to the river. All the offices are great, and fantastic canteen and a creche, and like really progressive in how they treat their examiners and all the examiners. And why is that? It's because they want their examiners to come to the office, because they realize the benefits of collegiality, of chatting, sitting in meetings. If I've got a difficult case, I can get up, knock on the door of my colleague next door and chat about it, okay? So that's why they make it very conducive. Great food. If you've got little kids, you can bring them to the creche. Good parking, nice offices, park-like grounds next to the... So this was great. But it quickly outgrew itself. So now they've got lots of other offices. They've got an office in Vienna, they've got an office in The Hague, and a few more spotting around because they just got so big, right? Because it's such a successful organization. So, but anyway, let's talk about Munich, which is like the hub, right, of the EPO. And so you've got all these examiners there. So it's very similar to the US system in the sense that you have a receiving section and they check that all the formal requirements are there, and then they send it out to the examiners. And just like in the USPTO, there are thousands and thousands of European examiners, and they all have an area of specialization, and then your application comes to him, okay, or her, the examiner. And so, and then, you know, they sort of write to you in the fullness of time. Now, the Europeans, unlike the Americans, do not overwork their examiners. So to be a European Patent Office examiner is quite a good job. It's very well paid. And you don't work particularly hard. Very difficult to get hold of an examiner after 3 o'clock on a Friday afternoon. In fact, after 3 o'clock on any given afternoon. And it's more expected that the quality of work is good rather than the quantity of work is impressive. So you can see immediately there's this distinction in approach between the US, where, you know, get your points, I want to see this productivity, and in in Europe, where it's like, okay, you don't have quite so much to do, but you need to do it properly, okay? And so immediately you've got a different approach from the examiner. The examiner in Europe is very much more objective, okay? First of all, he's a very erudite person, because by definition, to be a European patent examiner, you need to speak 3 different languages, right? You need to speak and be able to write and read English, French, and German, okay? If you can't pass exams in those 3 languages, you don't get to be a European Patent Office examiner, okay? So already the bar is high. So you've got these guys who are very sort of familiar with all these languages, right? Now there will be examiners who, you know, who their home language is German or their home language is English, and I think they try and sort of do that, because when you file a European patent application, you have to designate which language you want to prosecute it in, and that means that, so your spec can be in any of those 3 languages, that's fine, but you've got to designate a language of communication, and which must be English, French, or German. So if you say, I designate German as my language, then all the correspondence with the office is in German. You write to them in German, they write to you in German, and back again. And you can choose English, French, or German as the language of proceedings, it's called. And when you're an examiner and you're an expert in golf balls, you've got to be able to communicate in each of those 3 languages. So if you get an application for a golf ball, you're a golf ball expert, and the language of proceedings is German, well, then you have to write to the patent applicant in German. So you can already see that this is a clever person that you're talking to. He's not some, you know, like Korean off the boat or something like that who can barely speak English. This is a guy who knows his way around Europe per se. Also in Europe, critically, you get to chat to the European examiner as much as you like. It's not like in America where you have one shot and then it's a final thing. It's like in Europe, you know, he'll issue an examination report. You can write back and he'll say, no, I still don't agree with you because of this, this, and this. And then you get another chance to write to him. And then he'll say, listen, okay, I'll give a little bit of ground on this, but these are still the outstanding points. And this is wearing a bit thin now, so I'm only going to write to you one more time, and then I'm going to refuse it, okay? So it's very much at the discretion of the examiner, and you can see on many of the files that there's a continued back and forth. The examiner will write 4 or 5 examination reports to the applicant before he finally loses patience and says, I'm drawing a line in the sand. And then you, as an applicant, have the right of what they call oral proceedings, which is to say, okay, I accept that you've refused this application, but I demand the right to speak to you. and the examiner has to take a phone call or a Zoom or a Teams call where you can pitch your case orally to him, and he can say, no, I still don't buy it, or actually, fair enough, you've got a point, because for whatever reason there was a misunderstanding in the written communication or whatever. So you've got a right of oral proceedings, okay? And even then, when an examination, when an application is either finally refused or accepted by in the European Patent Office, and this is really cool, the examiner doesn't get to do that by himself. Okay, he draws a conclusion. He says, so he's been talking to you, and then he's either convinced or he's not convinced, and he said to you, we're done. And then you have oral proceedings, and he says, okay, we're still done. I still don't agree with you. I'm sorry, I'm refusing this application. He then has to take that document, the reasons for refusal or the reasons for grant, and he's got to take it to two of his chommies, including his supervisor, and he's got to convince them of it as well. So they have to sign off it. So it's called a votum for grant. So you don't get any decision out of the European Patent Office unless three very clever guys have looked at it and all agree that it should be refused or it should be granted. So you are getting an extremely high quality decision out of the European Patent Office. They are not biased against you. There is no xenophobia at all. So Europe is much, much more liberal than the US in that regard, okay? They don't care if your invention comes from Zululand or, you know, the moon. If it complies with the requirements of the European Patent Convention, then you are good, okay? So it's amazing. It's just such a pleasure. And the other thing is that, you know, a US examiner will just say no and give you no like feedback or hint or any sort of inference as to what he would like to see in the claims. But a European patent examiner will say to you, I don't like the way your claim is formulated now, but if you did it this way, I might change my mind. So he's a lot more accommodating in his approach, right, in my experience. So that's why it's such a pleasure dealing with the European. So what happens is, okay, so you get your patent granted before the European Patent Office, and then, you know, because three of them have agreed. If they say no, you have a right of appeal, and then that goes to the Technical Board of Appeal, and you get to argue your case, similarly to America, before three examiners, and then they say yay or nay. And then I think if it's finally refused, then I think your road is finished, but you can take it to the courts, because all of these are, in fact, you know, nothing is before the courts up until this point. It's all done by the European Patent Office. So, and then I think when your options are exhausted before the office, you can in fact then resort to the courts. But nobody really does that. I think the standard of examination is so high at the EPO, the courts will just, you know, you really, you know, the odds are stacked against you to take it to the courts, and then it gets horrendously expensive because you need advocates and barristers and all sorts of things. So not many people do it. Most people take it on the chin. Anyway, okay, so you get your patent granted, yay, by the EPO, and so there's a central office, and they grant your patent. The grant is published in the European Patent Journal, and then what happens is two things then kick into motion. One, and the most important thing is you now have 3 months after the date of publication in the European Patent Journal of the acceptance of your application. You have to decide which of the member states of the EPC you want to validate in. Okay, so, and that's when you say, oh, I want to go into Italy, UK, Poland, France, Germany, whatever. And then you take your European patent and you write to an Italian agent, because you've got to have a local address for service in each country. But it's a very simple process. They just go, cool. The Italian guy goes, cool, and he files it in Italy, and he's the address for service in Italy, and that happens in all these different countries around the world. Sometimes you have to translate into Italian, no matter what language it is, but there's something called the London Agreement, and most countries have now done away with filing the entire specification into Spanish or Polish or German or whatever. They say if it's one of the three languages of the proceedings of the EPO, which you will recall are English, French, or German, then it's fine. And I think in Spain and Italy and places like that, you just have to translate the claims into the language of the country in which you're filing. So if you're validating a granted European patent in Spain, then no matter which language it's in, English, French, or German, you just translate the claims and you put those into Spanish, because no matter the language of proceedings, the claims are always issued in French, German, and English. So, the whole description and all the examples might be in English, and your claims as granted are in English, and then but then they translate them into French and German as well, and that's all part of the granted European patent. You have to translate them into French and German at your cost, but all the claims appear, no matter the language of the description, the claims are always in English, French, and German. And then there are some other countries require the claims to be translated into their particular language, like Italian, Spanish, or Portuguese, or whatever. So that's pretty cool. But you've only got 3 months to do that. So if you miss that, you're done. You've missed that boat, and you can't then go back 6 months later and go, ooh, I meant to file in Spain. Do you mind? Can I still validate? Door closed. 3 months. Thanks for playing. And there are lots of countries there. I mean, I think there are about 40 member states of the EPC, including some African countries like Morocco. So you can validate a granted European patent in Morocco. And I think that's really cool. Morocco were ahead of the curve to sign up to the EPC on that basis, to be an extension state, even though they're not in Europe, to say, listen, if a European patent is granted, we're happy to take it on board in Morocco. Because the standards are so high, they believe in it. And then, you have a Moroccan patent, and then now all of a sudden the Morocco Patent Office is getting all the renewal fees because it becomes a national patent, right? So infringement proceedings, revocation proceedings, renewals, all happens then in Morocco, because once it's granted by the European Patent Office, they wash their hands of it. They say, we are just a granting facility. We're not interested in enforcement. We're not interested in invalidity or revocation proceedings. That all happens from now on in a national environment. So when you file your patent in Germany and you validate in Germany, the EPO has washed their hands of it. They said, we granted it, but now it's a German national patent. And so if you want to infringe, if you want to launch infringement proceedings or whatever, you do it under German law, you renew in Germany. Any fights you have, it happens in Germany according to German law. So it's really good for a country, because a country like Morocco has done nothing. A patent arrives, gets validated there. Now all of a sudden, the Moroccan Patent Office is getting all these renewal fees for this patent, which is cool. They don't do anything. And, the Moroccan patent attorneys are working on it. They're enforcing it. They're defending it, et cetera, et cetera, et cetera. So it's really good for a country. I mean, patents are a really good commercial provider. I mean, they provide, just before we talking about infringement or revocation or anything, they provide a lot of commercial incentives. It employs a lot of people at the patent office, in the private sector, not to mention the actual owner of the patent, who now says, well, hey, I've got this monopoly in Morocco. I'm piling in there. I'm going to make and sell my product in there. So, patents are good from that point of view. So to sign up as an extension state to the European Patent Convention, it's great. It's really good. So, that's typically how it works. And so, once you get your patent centrally granted, you as a patentee then must then decide, okay, in which countries am I validating it? And boom, off you go. Something which is interesting is that after the publication in the European Patent Journal, the publication of acceptance of the application, which is the grant date, you've got this 3-month window to validate in all the member states. But it also opens a 9-month window for opposition. Okay, so you've got to scurry around validating in all these different countries, but you've still got a little bit of exposure, because up until 9 months after the date of publication in the European Journal, anybody can write in and say, I oppose the grant of this patent, and this is why. And now all of a sudden, you've got opposition proceedings. So, but now you've validated your patent in Germany and Morocco and France and everything. So what actually happens is those patents continue to be national patents, but now you've got to go back to the EPO and fight this opposition. And it's heard before the EPO that those same 3 examiners who said yay, obviously, to grant, now they sit on the opposition board with a couple of chommies as well, so there's about 5 guys, and then each side argues their case. And then the opposition board says one of 3 things. It says, no, the opposition has no merit, the patent survives unamended. Or they can say, opposition boys have a point, but it's still patentable, but now you've got to amend your claims, usually limit your claims, etc., etc. In which case you go, okay, not ideal, but I'll take it. So now you still got your patent, but it's narrower in scope. So then you have to go to Germany and incorporate those narrow claims in Italy, etc., and amend all your claims in those countries. And then the third thing that the opposition board can say is, actually, the opponent has a very good point. No claims survive. You're dead. Patent cancelled. And that happens, each one of those scenarios survives unamended, survives with amendment, revoked or opposed, successfully opposed, happens about 1/3 of the time. And then you've got to go back and withdraw your patent in each of those countries. So it's quite a good self-regulating system. If you don't like the outcome of the opposition division, you can appeal it to the Technical Board of Appeal. And whatever their finding is, that's their finding. And again, you can take it to the courts, but most people call it a day at the Technical Board of Appeal. So yeah, so I think Europe is a great system, and you know, I've had very positive experiences of it. It's not cheap, but it's much better value for money rather than, say, for example, the US PTO, where you know, you have that bias and you only get 1 or 2 letters out of the examiner before you have to pay for your fees again, etc., etc. So it's very cool. The European Patent Office is very well run. Now, I freely admit to bias towards the European Patent Office because I am a European patent attorney. So I have passed their exams and I did practice before the office for 7 years. And what I liked about them was their rules are like, you can't believe it. Okay, they prescribe so many things, like right down to which courier companies are acceptable and which are not. So UPS, yes. FedEx, yes. Dawnwing, no. Okay, so you know, if you send your papers via Dawnwing, they won't technically accept it, etc., etc. And when I wrote my European qualifying exams, I failed one of them. Yes, I failed an exam. It's no big deal. You learn more from failure than from success, I tell you. So if you ever fail anything, don't give up. Don't be despondent. It's just the universe telling you something, and it's all cool. Just pick yourself up and do it again. But anyway, I failed one of my European qualifying exams by 3%. I was outraged. How could they do this to me? I'm brilliant. You know, they've made a mistake. So I go through my paper, can't find anything. And then I read the rules. And the rules said that each paper must be marked by 2 separate examiners, and each examiner must fill in a mark schedule. Okay. So I wrote to the European Patent Office and I said, send me my mark schedules for this paper that I failed. Sure enough, they send them. I look at them, they've been filled in by the same person, not 2 different examiners. Okay. And the rules say that each examiner must fill in a mark schedule, i.e. each one. So I wrote back and I said, these have not been filled in by separate examiners. They've been filled in by the same person. And you can see it. It's obvious. It's clear on the face of it. I'm going to appeal my decision. And they wrote back to me and they said, you're kidding, right? And I said, no, I'm not. You were the one who wrote the rules. I'm appealing on the basis. This is bad in law. And there was a period of silence. And then they came back and they said, okay, you've got a point. We will entertain your appeal. And so I filed my appeal documents and I had a set down date and everything. But cheeky monkeys, they set down the matter for hearing. You can only write your EQEs every year, right? Once a year. So there was a couple of months while we were arguing about whether it was appealable. And then they said, yes, it was appealable. And so then I filed my documents for appeal. And then they wrote back and said documents accepted. And then they set it down for an appeal hearing. But they set it down for an appeal hearing after the next sitting of the exams, right? Because it had taken so long with the months. So I was like, that's a bit fishy, but okay. And they said, no, we're really busy and, you know, we can't set it down next week. Sorry, it's only in 4 or 5 months' time, but, you know, we look forward to seeing you on the day, whatever. And they knew that I was going to be writing that exam again. And they knew that I would probably pass the second time around, right? So that's why they pushed the appeal out to after I had written the exam. And of course, I wrote the exam, and because I only had one outstanding, I was able to keep a lot of time and resource to the exam. And so, I did pass the exam the second time around. And let me tell you, the day that the marks were released, I got a call from the examining division to say, congratulations, you passed your exam. Do you still want to continue with your appeal? And of course, I said, no, it's fine. I don't need it now. I mean, my employer was quite prepared to fund the appeal while I hadn't passed. But as soon as I passed, they said, it's a dead rubber. Why? What does it matter? So your date of passing it a year earlier doesn't matter. So the appeal was withdrawn. But the fact of the matter is, the European Patent Office were prepared, technically, theoretically, to entertain that appeal because one of their many rules had not been complied with, and they hold themselves to their rules. So, good for them. But that's, maybe that's not an interesting story, but I think it exemplifies just how rule-orientated the EPO is. There's no wriggle room or discretion or anything like that. So, and if you know the rules, you know exactly how the system works, because you know that the European Patent Office will hold themselves to their own rules. So, it's a great organization. I like dealing with them. It's completely objective, and it's very predictable whether you're going to be successful or not, because, there are so many rules and they're objectively interpreted. So it's a great system. Not to mention that the examiners are intelligent, erudite, and are looking to give you. There's no incentive for them to refuse an application like there is for a US examiner. He's not on a marks-based thing. If he refuses it, he's got to convince two of his buddies why it's not patentable. So everybody, it tends to be objective. So it's a great system. So finally, now we look at the UK system, and the UK system is quite similar to South Africa, except that they have substantive examination as well. Their patent office used to be based in central London, and they still have a desk there where old school, you can go and put your papers down on the desk. But of course, now it's all electronic. Everything is email, electronically filed, etc., etc. But they still have the patent offices. It's a very small patent office in London, in central London, but nothing like the glory days, right? When you had this big Victorian building with the pillars and all of that. Those days are gone. And the UK had a system of, well, I don't know what they called it, but I called it spreading the love, whereby they kind of farmed out bureaucratic issues to cities that were kind of like economically depressed. So they built the patent office, the new patent office, in 1992 in Newport in Wales, which is like where? It's like in the middle of nowhere. It's about 50 miles from Cardiff, in the middle of Wales. Like, really? Newport? But the reason they did that was because now all the patent offices sit in Newport. You've got this big government office, and people go there for hearings, and all the hotels and everything. That whole town was uplifted because the patent office is there now. So the examiners live in the area, all the formal people live in the area, the hotels, the restaurants, they do well because patent attorneys are coming and going for hearings and stuff before the patent office. So courier companies are delivering papers, whatever. So just overnight, you can go from a sleepy little backwater to a humming, vibrant community just by putting an office there. And the Brits did that, and they did that with their deeds office, they did that with the patent office, they did that, the trademark office, everything is there. UKIPO is in Newport. But it's a clever idea. So so that's where they are, and they have a whole bunch of examiners there as well. Not as many as the EPO, because they don't have as many applications that are first filed in the UK, which need to be examined. But the UK guys are really good, and so you can file your patent in the UK. And now the UK Act, as I've mentioned many times over the course here, is very, very similar to the South African Act. And like, for example, just trying to look here, just get up. Section 25, which is the big section in South Africa, application, patentable inventions. The corresponding the corresponding provisions are sections 1, 2, and 3 of the UK Patents Act. So, many of the South African and Article 52 of the EPC. So many of the South African provisions have corresponding provisions either in the European Patent Convention or in sections of the UK Patents Act. The UK Patents Act was formulated in 1977. Ours was formulated in 1978. So there is no doubt that we took a huge leaf out of their book, and our act is so similar to theirs, which is why we study those RPC decisions, because they are they're so persuasive, because they're based, the wording is so similar between the two acts. And of course, there is a degree of regulation between the UK Act and the European Patent Convention, but because it's required that when you became a member of the European Patent Convention, you had to amend your act so that it substantially accorded with the European Patents Act. So the European Patent Convention concords with the UK Patents Act, which has got a whole degree of similarity with the South African Patents Act. So you can see just how similar we are. Look, I mean, there's differences: substantive examination, opposition, prior user rights, things like that. They all exist over there, but they don't exist in South Africa. But, to the extent we're talking about absolute novelty, to the extent we're talking about inventive step, all of that case law, all of that wording is highly persuasive in South Africa. So that's why the UK Act is so commonly cited, and we look so much to UK decisions. So there we have it. So that's quite interesting. So what happens? So what tends to happen is that after the international phase of the PCT, now I've got the national phase, and I've got to decide where I'm filing. What a lot of countries actually do is they will file a European Patent Office application designating all the European countries, but they also might file a couple of patents individually in some European countries, like, for example, the UK. So they've got the same application pending in the UK and the same application pending before the European Patent Office, both of which are being examined. UK tends to move a bit quicker than European Patent Office, so it often comes to pass that the UK national application gets granted. Okay, so now you've got your patent in the UK, it's all good, and then all of a sudden your European patent pops out and gets granted a year or two later, and then you file it in the UK. The Brits are on the ball. They will write to you to say, oi, you've already got a patent here. You filed it as a national phase all those years ago. It's granted under this number. It's the same applicant. It's the same title. It's the same subject matter. You can't have two patents drawn to the same thing. You tell me, which one do you want? Do you want the European one, or do you want the UK one? You can only have one, but it's up to you. Tell me. If you don't tell me in 3 months' time, I'm going to revoke the UK one, and the European patent will stand. So you can't have overlapping rights, right? You can't have dual patent rights. So I think that's quite interesting. So why would somebody do that? It's because, say you want to start commercializing in the UK, it's nice to have a granted patent behind you when you start making and selling these things. So what tends to happen is they'll often narrow the claims of the UK patent such that it goes through quickly because the claims are narrower, but they're completely focused on the commercial product. So they can get it out there. And then the broader European patent comes in later, and then that UK patent falls away, and you have a broader UK patent, which still covers the product which you've been making and selling, but you've been able to kind of like commercialize and get those revenue streams going. So that's kind of like a strategy which a lot of people use in filing both a UK patent and a corresponding EPO patent, such that the EPO patent will eventually take the throne, but you can have some protection in the meantime. Okay, sure. I've spoken a long time about those three systems. I didn't realize it was going to be quite that long, but hopefully now you have an understanding of the international, how patents are territorial. It's in the prerogative and the sovereignty of each country as to how they grant patents and how it works. To some extent, that has been addressed by the EPC, whereby countries will recognize a patent granted by the EPC is good enough for them, and they'll accept it into their country. The European Patent Office is a central granting authority, But after that, you've got 3 months to validate in each country, which is a member state, and then they convert to national patents, and you treat them as national patents on that basis from purposes of infringement, renewal, and revocation. So there we have it. Okay, good stuff. Now, I don't know if anybody has any questions about that, but I always regard that as a very interesting part of the syllabus because, you know, being involved in intellectual property, you are, because of this international harmonization, but also the differences from country to country, a lot of commonality, but a lot of differences as well. You are instantly part of an international fraternity. So you've got buddies all around the world, and you meet them at conferences, and you get to travel, and you go to the US, and you meet your agents, and whatever. And you know, it's really collegial. And one of the nicest things about this profession is that I have friends in so many different countries, because you know I file in those countries and I work with those guys there and everything. So it's really nice to be part of such an international sort of community, as it were. And it's something that I very much appreciate. So anyway, those are my final words on international practices. So that's why it's important to understand, you know, how different systems work. You don't have to have a fundamental understanding of the USPTO, but it's a good idea to have an understanding of the basics. Okay, right. Change the subject. We're now going to talk about traditional knowledge and how it relates to patents. Okay, so this is what I want to talk about. Okay. We're talking Dean and Dyer. We're talking pages 332 to 341. It's not a lot. And in particular, we are talking about the National Environmental Management Biodiversity Act of 2004, also known as NEMBA. Okay. So what is the purpose of this? Okay. So South Africa is not alone in recognizing the huge value that is embedded in traditional knowledge of our communities here in South Africa, and also, what we're going to focus on today, is the indigenous biological resources which exist in South Africa, which is to say the animals, the plants, the fish, the microbes, the bugs, all of which grow naturally in South Africa. They have huge value to us as a country, biodiversity. But we're not the only country who's figured that out. India, Brazil, Madagascar, Indonesia, all these places, they understand that they have this huge value in their ecosystems. And that is contrasted with the fact that places like Europe and to some extent America and Australia, they don't have this asset base, but they recognize the value of it. So our biodiversity legislation is designed to stop companies coming in and exploiting our biodiversity in the form of patents, etc., without any value flowing back to the local communities in South Africa. All right. So, and this is, I cannot emphasize this point enough. There is a lot of similarity between the Patents Act and the National Biodiversity Act, NEMBA. Okay, why? Because the Patents Act is focused on making sure that the creator of intellectual property gets the fruits of their creation, right? And that's section 45. You know, you have the right to exclude others from doing this, such that the applicant, the patentee, gets to enjoy the whole fruits of the invention. And NEMBA is based on exactly the same philosophy, that the curator, not so much the creator, but the curator of indigenous biological resources gets to share in the benefits that they yield. That's what NEMBA is focused on, is making sure that the local communities are not sort of don't go without when their traditional knowledge is exploited. Okay, so let's look at it in terms of an example. And the example I want to use is discussed in detail on page 339 of Dean and Dyer. But basically, it's talking about a cactus plant called Hoodia. And I think I've spoken about this before, but it's so important that it bears discussing again. Okay, so Hoodia, the actual species is called Hoodia gordoni, and the San people have known for thousands of years that if you eat the bitter tasting flesh of this plant, you are no longer hungry. Even though you've got no food in your tummy, it has a chemical compound in it which is known as a satiety agent, which makes you feel full and it stops you feeling hungry when you eat it. Okay, so this is extremely useful for the San because it allowed you to, hunt properly because your tummy wasn't rumbling or you weren't distracted by feelings of hunger, etc., etc. So you could really go for a long time. Okay, so the San have known this for thousands of years, and they've just been getting on with it, right? So this cactus grows in, parts of South Africa where the San live, and it's just been part of their culture from like almost day one. Along comes the Council for Scientific Research, Scientific and Industrial Research, the CSIR, and they actually extract the active compound from the flesh of this plant, okay? And it's a compound known as called P57, okay? So they isolated the active ingredient. So what they did was they took a whole lot of material and then they passed it over filtration and this and that and the next thing, and they got this P57 concentrate. So then you didn't have to eat the whole plant. You could just drink this or take it as a tablet or something like that, and then you didn't feel hungry, okay? This had huge implications for the Western weight loss criteria, right? So they patented the isolation, the extraction of this compound P57. And then there was outrage because people said, oi, you just trading on the knowledge of the San. The San have known this for years, but now you just get to isolate this thing, and now you think you can patent it. That's not fair. Okay, the San never isolated it. They were just chomping on the actual flesh of the plant, but they were getting to the same point, which is this P57 was coursing through their bloodstream and causing these feelings of satiety. So that's not right. And the CSR, to their credit, said, actually, you're right. Okay. And what they did was, so the CSR was initially criticized for exploiting the San's traditional knowledge without appropriate recognition thereof, and most importantly, without appropriate benefit sharing with them. So after negotiations, the role of the San in the discovery and development of the properties of Hoodia, the San's traditional knowledge was recognized and acknowledged by the CSIR, and then the South African San Council and the CSIR contractually agreed to recognize the San people as the traditional knowledge holders of the Hoodia plant and to allocate them a share of the profit derived from commercializing the active ingredient. As a result, the San Hoodia Benefit Sharing Trust was established, and the primary objective of the trust is to ensure that the monies received are for general development and training of the San community. So that's pretty cool, right? So when somebody comes along with some resource and sort of utilizes or levers the traditional knowledge of a community and starts making money, then in accordance with NEMBA, money flows back to the community. So it's just like the Patents Act, whereby the original holders of the knowledge get to share in the benefits that come from exploiting it. And that's pretty cool. And there are other examples of where this has happened with indigenous resource in South Africa. And the two big ones are rooibos tea and to some extent honeybush tea, and then pelargonium, which I don't really know about. But both of them are covered in Dean and Dyer, and you should read both of them. Okay, so I'll come back to the benefit sharing aspects of it now, but I just actually want to talk about Hoodia because Hoodia unfortunately doesn't have a very happy ending, because although they got the patents and there's a benefit sharing agreement, etc., and the trust, the San Hoodia Benefit Sharing Trust, was established, no money actually came from the patents. And that's because they're so easy to circumvent. Okay, so what they were doing is they were just isolating this P57 from the flesh of the Hoodia plant. But what other people were saying was like, I don't have to do that. I just buy the plant, chop it up, and put it in a pill. And I don't have to extract nothing. I don't have to isolate nothing. I just give you this much of the plant. I chop it up. I compact it down. We take a pill. It's fine. Doesn't infringe the patent, right? So, and they don't have a patent on it either. It's just they just do it. So there's a million of these Hoodia compounds which are out there, which don't use the extract, don't use the isolate. They just use the flesh of the plant, and they don't grow the plants in South Africa. They've grown them overseas now. So there's really nothing we can do about it. So that's an unfortunate part. The other thing is that somebody somewhere along the line learned to synthesize how to sort of make P57 without extracting it from the plant material, and that's actually cheaper than isolating it. So now they make P57, they synthesize it, a synthetic P57, and that's also available, and that also avoids the patent. So these patents haven't really been of commercial use to the sand community, which is a shame, but that unfortunately is a commercial reality of how things work in the real world. The same is not true for rooibos. Rooibos is shared by the San and the Khoi people of South Africa. Each has their trust, and rooibos, of course, prints money, man. I mean, so many people drink rooibos, not only here in South Africa, but in England, in Germany, in the United States. I love going to England, and you go and visit somebody, and they say, "Oh, are you coming from South Africa? Would you like some red bush tea?" And I say, "You mean rooibos?" And so that's quite funny. They love it over there, and so it's a business which is pumping, and so both the San and the Khoi communities have actually made a lot of money off rooibos because benefit sharing agreements are in place with them as well. So the money's flowed from that, but no money from Hoodia. So you win some, you lose some. But at least NEMBA, the Biodiversity Act, puts in place the requirements for the monies to flow back to the communities, right? And it's exactly the same philosophy as the Patents Act. If you are the custodian of knowledge, then you get to share in the benefits of it, and I think that's a big thing. Okay, just as an aside on Hoodia, so how the CSIR got interested in it in the 1970s is that in apartheid South Africa, particularly in the 60s, there was a very strong military-industrial complex in the country, right? The South African Defence Force was a critical part of propping up the apartheid government, and they had a lot of resource directed their way, not only in terms of weaponry, but also training and sort of being able to survive in the bush of South Africa, so that the special forces could be dropped into the middle of nowhere in counterinsurgency actions and even worse, hunting down operatives and things like that, and they could survive out there on nothing, basically. Didn't need to be supplied, didn't need to be resupplied, could live off the land for weeks on end, right? So what they actually did was they conducted an audit, the South African Defence Force in the 60s, of all the plants and animals in South Africa, and which were poisonous, which you could eat, which you couldn't eat, and which were good for this, that, and the next thing, right? The medicinal qualities of all the different plants, which were indigenous to South Africa. I mean, a hell of a study, and it's all written down and it's all codified at the CSIR. If you've got a headache, chew this. If you've got, if you are bleeding, crush these leaves and put them on the wound, and then that stops the bleeding. So we've got all of this knowledge out there, which has been known by the sand community. The SADF, the apartheid government, weren't interested in sort of chatting to the local communities to say, how do we do this, how do we do that? They just said, we'll go do it ourselves. And so they went and they reinvented the wheel, literally reinvented the wheel, and codified all of this knowledge about all the plants and animals that occur locally in South Africa and what they can be used for. And that is how they came across Hoodia, to say, listen, if you're hungry and you are in the desert up in Uppington or whatever where Hoodia grows, if you munch on this cactus, then you don't feel hungry anymore. And it was one of the many, many entries in this codification of all of the fauna and flora of South Africa, the benefits, the advantages, the disadvantages, what to watch out for, what to eat, etc., etc. So I thought that was quite interesting. And that's, of course, CSIR clocked this and said, "Oh, that's very interesting about Hoodia. Let's see if we can isolate the compound." And of course, that led to all of the work, etc., etc. So yeah, so Hoodia is a very interesting story about South African resource, etc., etc. So okay, so I mentioned earlier that there's an international burgeoning recognition of the wealth that's contained in the biodiversity and traditional knowledge in any given country, and that's the same for Brazil. It's the same for India, and so there are these protocols. So, like the Convention on Biological Diversity, the CBD, and then the Nagoya Protocol, which says that the objective of the Convention on Biological Diversity is to ensure fair and equitable sharing of benefits arising from the utilization of genetic resources in a country. So, and they all talk about these terms: biodiversity, which is the term given to the variety of life on Earth and encompasses plants, animals, and microorganisms. Indigenous biological resource, which is defined in NEMBA, any living or dead animal, plant, or other organism of an indigenous species, derivatives thereof, genetic material derived therefrom, etc., etc., excluding human genetic material, exotic species which have been introduced into the country, as opposed to an indigenous species, which is defined as a species that occurs naturally in a free state within the borders of South Africa. Genetic resources, traditional knowledge, bioprospecting and biopiracy. These are the two aspects of the Act which NEMBA really focuses on. So bioprospecting is the term used to describe the process of searching for new potentially valuable products when such products are based on biological resources and traditional knowledge, and then commercializing such new products. This includes research on or developments or applications of indigenous biological resources for commercialization or industrial exploitation. So I want you to know all of these terms, right? And how it fits into NEMBA. So bioprospecting is lawful because you'll have all your paperwork, and there's a lot of paperwork prescribed in terms of NEMBA. But biopiracy is the term used to describe the situation where traditional knowledge originating with indigenous people is used by others for profit without permission from and with little or no recognition of the indigenous people themselves. Okay. And biopiracy is what we're really trying to prevent in terms of NEMBA. So I really want you to read the pages in Dean and Dyer relating to biodiversity, traditional knowledge, etc., etc. Traditional knowledge is kind of defined as knowledge, know-how, skills, and practices that are developed, sustained, and passed on from generation to generation within a community, often forming part of its cultural or spiritual identity. And that's basically what we're focusing on. So if we look at the National Environmental Biodiversity Act, so it's based on it's designed to ensure that indigenous communities are compensated when an invention is based on or derived from traditional knowledge, and where the indigenous community is the owner of that traditional knowledge. So the objectives are to provide for the management and conservation of biological diversity within South Africa, the use of indigenous biological resources in a sustainable manner, and the fair and equitable sharing among stakeholders of the benefits arising from bioprospecting involving indigenous biological resources. So, you've got to have a permit to bioprospect. You've got to have a benefit sharing agreement in place when you move to commercialization. You've got to have material transfer agreements in place, and you've got to sort of keep the ministry advised at all times of exactly what you're doing. So this, of course, dovetails perfectly with the Patents Act, right? Because filing an application for a complete patent application is regarded as commercialization in South Africa. And the controversy lies in the fact that bioprospectors draw on indigenous biological resources and or traditional knowledge, and then they patent their findings without recognizing or acknowledging that the knowledge is not new, was not invented by the company in question, right? The European or the German drug company, for whatever. This would deprive the local community of the rights and the revenue streams, and so that they, of course, had developed over the years, and that's simply not right on any level. And that's what the National Environmental Management Biodiversity Act, NEMBA, is all about. So what I want you to know is, I want you to focus on, and I'm going to leave this kind of some degree of self-study for you, because I want you to read these pages of Dean and Dye and kind of get your head around it, because trust me when I tell you, you need to understand the similarities between NEMBA and the Patents Act. You really, really do. And you need to understand how they dovetail together, how they have commonality or similarity of purpose, and how they go about doing that. Because the Patents Act was actually amended in 2005, so that in order to lodge a complete application in South Africa, the applicant must state whether or not the claimed invention is based on or derived from an indigenous biological resource. And as a result, every application filed from the 14th of September 2007 is required to lodge such a declaration on the form P26. So this amendment in 2005 introduced a new form which has to accompany a South African patent application, the form P26, and it's a declaration about whether you've used an indigenous resource or not. If you say no, that's fine. You go down one path, you don't have to worry about it anymore. If you say yes, I have used an indigenous, then you need that flicks open a whole new work pathway whereby you have to, if the applicant acknowledges that its invention is in fact based on an indigenous biological resource, the applicant must submit proof of his title or authority to make use of the resource by lodging one of the following: a copy of the permit for bioprospecting in the first place, or proof that consent has been obtained, a material transfer agreement, a benefit sharing agreement, proof of co-ownership of the invention, so that the community gets their fair share. So the P26 requires that of any applicants going forward. So it's just like an invention where if you say, I'm not the inventor, but I have acquired the right from the inventor to apply, and here's my deed of assignment, the NEMBA Act says it's based on indigenous biological resource. So technically I'm not the inventor, but I've isolated it, or I've used it in a new compound or whatever, but the local community is the co-inventor. Here's the material transfer, here's the benefit sharing agreement, etc., etc. So showing that you've derived the right to apply from the local community. So you can see the similarity between NEMBA, the requirements of NEMBA, and how it dovetails with the Patents Act. Okay, and I think that's really important. And it's really important to understand how this other act goes to the same principles as the Patents Act. And it's important to understand what documents are required in terms of the P26. It's important to note that the P26 is a declaration. There is one other form which must accompany a patent application, and that is the P3, where you declare that you are either the inventor or you've acquired the right to apply for the patent from the inventor, and it's the first application, etc., etc. Both of them are declarations. What does that mean? That means that if they contain a false statement, which you knew or ought reasonably to have known was false at the time of making the declaration, that is a grounds for revocation of the patent, okay? So both the P3 and the P26, super important documents which are required to accompany a patent application. You won't get a granted patent in South Africa unless both of these documents are completed. And if you've made a misrepresentation on either one, your application is liable to be revoked. So we take this stuff seriously, okay? All right, so again, I can't emphasize this enough, we need to be able to talk about the similarity between NEMBA and the Patents Act, both in philosophy and sort of how they get it together. Okay, that's it. That's what I wanted to talk about in terms of traditional knowledge insofar as it relates to patents, particularly biodiversity, etc., etc. We're now going to talk about the intellectual property policy of the Republic of South Africa, phase 1. But we are only going to do that in 5 or 10 minutes time. So we're going to take a break now, go make a cup of tea or whatever, and it's 10:45. I'll come back in about 5 or 6 minutes time. and we'll pick it up then, and then we can close off the discussion today. Unless there are any questions, I'm going to switch off for 5 minutes, and then I'll see you in a few minutes' time. No questions? Good stuff. Okay. Cheers, guys. We'll see you in 5. Take a break, make a cup of tea, and we'll see you then. And we're back. So now we shall spend maybe 45 minutes or so chatting about the IP policy. And again, this is a hugely important lecture today because the IP policy is a very important part of the curriculum. And so you really have to have a good working knowledge of this. So, Danae, did you say something? Okay, all right. So, right. I'll leave it up to you to decide whether the Patent Office is requiring, or our patent legislation is requiring of improvement. But it seems to be generally considered that in terms of the National Development Plan, which has gone a bit quiet recently, I have to be honest, but you know, it's out there. There is a feeling in government that we need to bring our patent system up to concord more with what they talk about as international best practice. So what they say is that there are perceived shortcomings in how we do things at the moment. And the biggest one that they don't seem to like is the fact that we don't have substantive examination. Okay. So they say this allows really rubbish patents to be on the register and to be granted in South Africa because they're simply not examined. So I mean, you could literally get a patent for a wheel in South Africa. Nobody's going to look at it, and you know, you're good to go. And then you can start flexing that on the population as large, and that would just lead to hassles. Okay. Of course, the Act is designed to stop that in the sense that, you know, we have Section 69 about one bad apple in the barrel prevents you from asserting your patent. You know, you've got your conduct of the patentee in granting relief, both in terms of, you know, amendment and things like that. So conduct of the patentee is mentioned several times in the Act, and it basically has got consequences that if you knowingly hold an invalid monopoly in terms of the Patents Act in South Africa, there are consequences in terms of the Act. So, you know, there are a lot of incentives to make sure that you hold valid patents in South Africa. But they still feel that substantive examination would be an improvement. They feel that, you know, having an opposition procedure, both pre-grant and post-grant, would be helpful. So there would be another way to get rid of a bad patent rather than just having to approach the High Court in terms of the Court of the Commission of Patents by if you want to revoke a patent. This could be a sort of bureaucratic hearing, just like in Europe, where the examiners hear it at the South African Patent Office and they entertain opposition. The other thing which they're looking at is you know, leveraging more rights in terms of the trade-related aspects of intellectual property, which would basically give government more walk-in rights for pharmaceutical patents in times of dire need, give them expropriation rights, give them better compulsory licensing access to drugs when there's a plague or something else like that. Right now, there are flexibilities that are built into TRIPS that are not really here in South Africa. South Africa hasn't embedded into our legislation, and so this document looks at maybe taking it a step further to give government increased access. They're talking about lowering the standards of, or raising the standards of patentability so that only proper patents are granted, you know, not these, you know, these patents which have got low standards of inventive step and things like that, because they're just more a nuisance than anything else and don't really encourage innovation. So that's one of the things the IP policy document looks at. And then the third one is the introduction of a so-called utility model or a petty patent, which will allow small, medium guys to get sort of short periods of exclusivity on sort of lower grade innovation, which probably wouldn't make it as a patent, particularly if we're talking about increased requirements of inventive step, but would still give short periods of exclusivity, enough just to start a business or something like that. So they talk about
the promotion of economic empowerment through the implementation of a utility model to support the registration of patents by small, medium, and micro enterprises, historically disadvantaged individuals, and companies operating in the formal sector. This would entail enacting an exclusivity right similar to a patent granted by the state to an inventor for a fixed period of time. However, the terms and conditions for granting a utility model are slightly different from those for an ordinary patent, including a shorter term of protection and less stringent patentability requirements. So you can see, so they're really looking to sort of simultaneously strengthen our patent system, make it more robust, but also lowering the barriers of entry and making having intellectual property more sort of the government can have more access to it than it presently can. But trust me when I tell you, the government can have a lot of access at the moment. Section 4, Section 76, compulsory licensing. The requirements of TRIPS are, yeah, we can take it a step further, but I think it's sufficient what we've got now. The fact that we don't substantively examine in South Africa is given a lot of stick. Okay, we feel that we're not holding our own on the international stage. We're just a depository system. What's the point of that? Well, the point of that is, almost all patents which are filed externally in South Africa have corresponding applications in examining jurisdictions, be they Europe, be they the US, be they Australia, be they China. So the patents which are examined, which are filed in South Africa, are going to be examined somewhere else, often 2-3 times, right? So the argument exists, well, why do we have to do that again? Are we really going to add anything to the party? Are we really going to pick up something that the Chinese, the Americans, and the Europeans and the Australians haven't picked up already? Maybe, maybe not. Okay. So, why do we have to subject this thing to another round of examination when it's already been examined elsewhere? And our Act currently includes the requirement to import any limiting amendments made on corresponding applications around the world. Okay, and that's the conduct of the patentee, which I was talking about earlier. That exists. So, if he doesn't introduce the limitations that examination in Europe, for example, required, then his patent in South Africa is bad. He won't be able to assert it. He won't be able to he can start proceedings for infringement. He's not going to be successful. He's not going to get damages. And as long as he's got one bad claim, he's not going to be able to assert other claims. So Section 69 really sorts that out. Okay, so do we really need substantive search and examination? Well, coupled to the fact that it's going to massively increase the cost of applications in South Africa, right? The examination fees are going to have to go up because we're going to have to pay for our own cohort of examiners, and my fees are going to go up because I'm going to have to engage with these guys and basically convince them that it is patentable. And all I will do is I will take the corresponding European patent prosecution history and I'll put it before the examiner and say, I want to amend to my granted European claims. They're considered novel and inventive, and good luck to the local examiner if he says, actually, no, I don't think so. Then we've got a fight in our hands. But I'll bet you 9 times out of 10, he'll just roll over if you advance claims that were granted in Europe. So is it really achieving all that much? Maybe, maybe not. But what it is undermining is the fact that South Africa is presently a very cost-effective place to file, okay? So people file here in South Africa, it costs, I don't know, $1,500 to do that. Now you've got a granted patent in South Africa, the gateway to Africa, 60 million people, the richest country in Africa, and you got all of that for $1,500. And all that you're required to do is that when you get your granted patent in the US or get your granted patent in the UK, you just amend your South African patent to reflect those claims. Boom, we're done. So lots of people file in South Africa because you get a lot for a little bit of money. Now what they are changing, they're changing that paradigm. They're now saying, well, you still get the lot, you still get the gateway to Africa, you still get 60 million people, but now it's going to cost 3, 4, 5 times as much because we've got this examination as well. And I do worry that a lot of people are going to go, is it worth it? It used to be $1,500, now it's $6,000. Maybe I won't file in South Africa, because cost of filing in a country is a big factor about whether you should file there or not. And I think by trebling or quadrupling the cost of filing is going to impact our filing numbers. And like I was talking about earlier, the more patents you have filed in the country, the better. There's work for me. There's work for the patent office. Money flows into the country. Renewal fees are paid, etc., etc. It's just good for the fiscus. And so we should be encouraging people filing patents in South Africa, not so much putting up barriers. But it is what it is. The National Development Plan, through the IP policy, is of the view that we are not reflecting best practice internationally in our patent system. So they have a number of improvements that they would like to implement. And these are set out in Chapter 7 of the policy. So we'll just go through each of those quickly now. And this is phase 1 of what they want to be doing. So they talk a little bit about public health. They talk a little bit about local manufacture and export in line with industrial policy, and that's fine. That doesn't really impact the IP, in particular the Patents Act. Oh, one thing I do want to do right in the beginning, it says of this document, I think it's on page 2, page 3. Okay, statutes relating to IP in South Africa include the Intellectual Property Rights from Publicly Financed Research and Development Act. We spoke about that last week. The National Environment Management Biodiversity Act. We spoke about that today. The Patents Act. We've been speaking about that for the last 5 months. Merchandise Marks Act, Copyright Act, Designs Act, Plant Breeders' Rights Act, Trademark Act. Through your LLM, you have received, you've been exposed to all of those. Because I know I've mentioned plant breeders' rights. It's not part of the syllabus per se, but you know what a plant breeder's right protects. So statutes related to IP in South Africa, in terms of your LLM, you have been exposed and you have a working knowledge of almost all of them. So you should pat yourself on the back because that's a good one. Okay, that's just to go. Now let's talk about phase 1. So phase 1 talks about the following issues: local manufacture and export in line with industrial policy, patent substantive search and examination, patent opposition, patentability criteria, disclosure requirements, parallel importation, exceptions, voluntary and compulsory licenses, IP and competition law, and the rule of law and legal certainty. Okay, so I'm not really going to talk about IP and public health. I'm not really going to talk about local manufacture, but I am going to talk about substantive search and examination, right? Okay. So it begins, boom, straight out of the blocks. It is a matter of much debate that South Africa does not conduct substantive search and examination prior to the grant of patents. Section 34 of the Patents Act, and you will refer, you'll see that I said Section 34 is relevant to the discussion of artificial intelligence as an inventor, because Section 34, read together with regulations 40 and 41 of the patent regulations, has the effect that CIPC only conducts examination in relation to the formalities of an application. So South Africa employs a so-called depository system. Okay, they do, to their credit, go on to discuss the benefits of the depository system, but then they focus on what they consider major drawbacks for both the producers and users of IP resulting from the depository system. And they then go on to say the introduction of substantive search and examination will result in greater legal certainty for patent owners and ensure that the public interest is served by ensuring that the patent system truly promotes innovation. So what they're trying to sort out is sort of dodgy, shady patents coming onto the system, which, you know, is fine. So the authors, the architects of this policy do recognize that, you know, South Africa simply doesn't have the resource to hire the thousands and thousands of patent examiners that are necessary for a full-blown examination of every application that comes to the door. So the SSE approach would take into consideration the nation's capacity constraints and legitimate public interest by prioritizing certain sectors, but which would not conflict with TRIPS. Okay. So what that basically says is they're only going to examine certain applications insofar, and they're going to be focusing on medicines and pharmaceuticals initially. Okay. And they're currently training up a cohort of about 20 CIPC, and I quote, has gone to great lengths to capacitate a very able cohort of patent examiners. The examiners are all experts in their respective technical fields, with significant number holding PhDs. The examiners have received theoretical and practical training from South African institutions, WIPO, and some of the world's most efficient patent offices, including the EPO and the Japanese Patent Office. In particular, CIPC has been working closely with the European Patent Office pursuant to a memorandum of understanding between the two offices. Okay, so what does this mean? It means we've now got about 20 or 30 examiners ready to go at CIPC. And they're rolling the system out, I think, in the next few months, where they're giving soft examination reports. So applications which are filed with CIPC, which relate to these areas of pharmaceuticals and medicinal drugs and things, will now get an examination report, which I, as a prosecuting attorney, am free to ignore. But it's good practice for them because they get to kind of like start these examination reports and sort of just kind of to start to spin up in their role as examiners. In due course, I will be required to respond and to rebut the objections raised in these soft examinations reports. But for the moment, they're just there to just see how it goes. As a profession, we are encouraged to respond to them because it's good training for these guys, right? It's good training to say, listen, this is the kind of response you can expect from me when these soft examination reports turn hard. So it's really interesting. Substantive examination, what do they call it? Substantive search and examination is being rolled out. It's in a trial phase, but it's here. So bring it on. I think, you know, I'm looking forward to arguing with these guys. I'm looking forward to locking horns with them. It's adversarial. I have to convince them to come around to my point of view. I have to concede, claim ambit. I have to make limitations. It'll be fun. I'm looking forward to it. As an attorney, that's what I'm naturally inclined to do, is argue with somebody. So bring it on. Let's see what they got to say for themselves. So SSE is coming, baby. And let's embrace it. It's here to stay. Let's talk about patent opposition. It says here, by their nature, opposition proceedings can achieve a range of policy aims in respect of substantive patent examination, including harnessing all available information, encouraging domestic inventors to increase their technological expertise by providing an incentive to pay attention to patent applications as they are granted, providing an increased degree of certainty regarding the validity of patents, and limiting the need to engage in time-consuming and expensive patent revocation proceedings. And of course, we've discussed that patent ratification, it's a high court action, only takes place in the Court of Commission of Patents and then gets appealed to full benches and SCAs and all sorts of things. So yeah, let's not go there. So they talk about three types of opposition proceedings that they're talking about. First is a process that permits third parties to submit information that is relevant to the consideration of an application for a patent, which is sometimes referred to as third-party observation mechanisms. So basically what this means is, you know, I'm aware that my competitor has filed a patent application. Before it even gets granted, I dive in and I write to the examiner and I say, listen, but I know this patent application is on your desk, and I don't think you should grant it for the following reasons. And have you considered these pieces of prior art? So it's an observation by me, a third party, and I'm just trying to give the examiner some hints to say, you know, I don't think you should be doing this, but you know, it's up to you, but please consider my response. Okay. And then curiously, our guys contemplate what they refer to as the second pre-grant procedure, in terms of which a third party may actively oppose the grant of a patent at some point between the submission of the application and the making of a decision on whether a patent should be granted. So I'm not sure I really appreciate that difference between that and third-party observations. But anyway, it's a pre-grant opposition. So, okay, cool, whatever. Happy with that. And then third and finally is the one very similar to what I was talking about in Europe earlier, whereby a post-grant procedure in terms of which a third party may appeal against or review the grant of a patent ordinarily within a specified period as determined in domestic law. So that's when it's granted, it's published in the patent journal, and then, you know, away we go. So yeah, I think patent opposition is a good thing. It provides an opportunity for public intervention in the patent application process. And, the process will obviously be made open in order to benefit the state and South African industry and society. So, I think patent opposition is great. I haven't heard any noises coming from the Patent Office about it, but it's definitely provided for in the policy, and it would definitely improve the quality of the service offering and make us more aligned with international best practice. So yeah, I like it. I like patent opposition. And again, as an attorney, any chance for an argument, I'm keen. Where do I go? So I'd love to be able to oppose and defend oppositions in South Africa. So I look forward to that. So guys, you must read all of this. This is 7.1.3. You need to be reading this. I'm just glossing over them, but I want you to be able to dive down into them. Patentability criteria. So here we go again, international best practice. Patentability criteria will be developed in order to promote genuine innovation through the patent system in South Africa. Such criteria will be implemented in the process of examination and will aim to strike the optimal level of IP protection, promote innovation, and balance the rights of IP holders. It is recommended that patentability criteria actually are embedded, form part of the Patents Act, as well as any subsequent regulations, etc., etc. So they talk about Australia as an interesting example, whereby in 2012, Australia adopted legislation which upwardly adjusted standards for patentability. A recent report of Australia's Productivity Commission reveals that the 2012 reforms, unfortunately, did not adequately raise the bar, and hence the same jurisdiction is currently considering further changes, particularly to the inventiveness test in Australian law. So, there's that phrase, first he giveth, then he taketh away. So what he's giving us is a vehicle for lower standards of inventiveness, which is the utility model. Okay, so the utility model got low standards of inventiveness, but it only lasts for 10 years. It's ideal for an SME. But so first he giveth, but then he taketh away, because he says, but if you want a patent, if you want to enter the patent arena, then I'm going to make it much tougher to get a patent, because you've got this option of a utility patent. If you want to go the patent route, it's going to be good, because the patent route is 20 years. It's the real deal, right? So you've got to we're raising the bar for patents, but we're giving you an alternative vehicle to still enter the market, albeit just for 10 years. So you can see that's the strategy. And I got to say, there's some merit to that. I do like that. By giving me options, I can choose the most commercially relevant strategy for me. If I'm a big company with big resources, I go for patents. If I'm an emerging company, if I'm a small to medium-sized enterprise, maybe the utility model is right for me. And that's great, because you want people to engage with IP, you want people to use IP, but one size doesn't fit all, and you want the most appropriate vehicle. So I like that. Okay. 7.1.5, disclosure requirements. So this is pretty cool. This takes it another step. Some countries, many countries like India, have got disclosure requirements at the meantime. And basically, what it means is that in order to gain a full, fair understanding of a patent application, we are now going to require applicants to adequately disclose the nature of the invention therein, and to provide information regarding the status of similar and related applications filed in other jurisdictions. Currently, you don't have to do that in South Africa. Currently in South Africa, you don't have to say, I've got a corresponding European, I've got a corresponding Chinese or whatever. You just file it, and then there's an obligation on you not to hold an invalid claim on the register. Cool, that's it. But now they're saying, if your South African application is the member of a family, and you've got corresponding or even related similar applications in any other jurisdictions, you've got to tell us. You've got to give us an information download to the South African authorities to say, I've got this one in America, I've got this one in Europe, I've got this one in China, this one in Australia. They correspond to the South African application, and it's on file. And that will make things so much easier, because it then means that you don't have to search around on international databases. It's not the biggest search in the world to do what's called an equivalency search, which reveals the patent family. But if you get the applicant to do it, that'll be really good, because then you can go and have a look at the corresponding Australian application and say, oi, you made this limitation there, but you didn't do that in South Africa. Why is that? And it's also good for our examiners, because they get to say, I see you did this in Australia. I like that. I require you to do that in South Africa. I mean, they could do it anyway, but it just makes it easier, and it puts the applicant on the block. So I think it's a good idea, this disclosure requirement. And this is all in line, with the trade-related aspects of intellectual property agreement, which, they deal with quite a lot in this policy document. Okay. Parallel importation. We have discussed this about under exhaustion of rights, which we discussed that last week. But here we're really talking about sort of drugs, because often a drug is available for, I don't know, 100 Rand a pill in South Africa, but in India it's only 20. So it's very easy to go and buy a container load of these pills in India for 20 Rand a pill. Even the costs of shipping them to South Africa, importing them, distributing, your costs are still only 50 Rand a pill. You still make 50 bucks a pill, right? So can you do that? And that's what's called parallel importation. They're made by the same examiner. They're just available at a different price in a different jurisdiction. So you buy them in that jurisdiction and you import them into South Africa, where there is nonetheless patent application. So South Africa's unique developmental needs, particularly in public health is a big area of focus, require the exploration of every legal opportunity to support the viability and expansion of the public health system, including, in the case of patented medicines, the ability to purchase said medicines from any external territory that is necessary. The implementation of parallel importation will be undertaken in a controlled manner, pursuant to consultations with respective stakeholders. Okay, so right now, parallel imports placed on the market in one country and brought into another without the consent of the patent holder. That's what parallel importation is. So they're not counterfeit, right? They're made by the same guy. And so in terms of the TRIPS agreement, this gives members the autonomy to determine their own regimes for the exhaustion of rights for patents, right? And we've discussed this. So, that case about the importation of the agrochemical, it's about if you buy it from the original manufacturer, his rights are exhausted. If you buy it from his agent, then the rights are exhausted. But if you buy it from a licensee, then you've got to check the terms of the license as to whether it can be sold in South Africa. You know the case about that. We discussed that last week. So that's what South Africa says. But we've got a bit of a problem, because we've got another act here called the Medicines and Related Substances Act 101 of 1965, which says that notwithstanding anything to the contrary contained in the Patents Act, the Minister of Health may prescribe conditions that determine the rights with regard to any medicine under a patent granted in the Republic, and which shall not extend to acts in respect of such medicine which has been put onto the market by the owner of the medicine with or without her consent. So what that basically means is that the Medicines and Related Substances Act is in conflict with the Patents Act. So how does that work? So the narrow interpretation of Section 45(2) of the current Patents Act, in its current form, could potentially give rise to challenges should parallel importation be pursued. Hence, there is a need to clarify in the Patents Act that parallel importation of medicines in the manner prescribed in the Medicines Act does not constitute an infringement of the Patents Act. Okay, because right now, the Medicines Control Act says you can do one thing, but a narrow interpretation of the Patents Act says, you can't, in terms of that case law. So there is conflicting advice there. So that's, I encourage you to read this section on parallel importation. It's a very interesting discussion. And, in terms of international best practice, it's quite a good question as to which act should be amended. Should parallel importation to be allowed per se, or should we give more emphasis to the exhaustion of rights doctrine? Interesting question. Okay. The other thing that I want to talk about is the BOLA provisions, research and experimental use. Yeah. licenses, compulsory licenses, and then government walk-in rights. And I think, and then we're probably done. Okay, right now, you know, we've spoken about BOLA, right? So South Africa incorporated the BOLA exemption in a 2002 amendment to the Patents Act. And this provision is an important tool to assist generic producers to test a patented product before the end of the term of the patent, thereby allowing the entry into the market as soon as possible once the patentee's rights lapse. Consultations with stakeholders have confirmed the importance of this measure in accelerating the entry of generic competition. This will likely be enhanced with the full operationalization, never heard of that word, that's a great word, okay, of the South African Health Products Regulatory Agency. So basically what they're saying is, so you know, BOLA allows you to, before the expiry, there's a patent on the active pharmaceutical ingredient. Generics are poised, waiting for the patent to expire. They can start putting their dossiers together. They can start doing all the testing, bioavailability and toxicity testing, get their dossiers in. They can't make, they can't import, they can't stockpile, but they can at least have their dossier ready to go when the main patent expires. This is considered a good thing. And so they're looking to strengthen this and possibly even expand it a little bit more in terms of best practice. But what is not allowed in tons of South Africa is research and experimental use, okay? Right now, those are still acts of infringement in terms of South Africa, a literal interpretation of the act. So what they're saying is the IP policy is looking to outline an intention to develop and carefully craft a set of exemptions for research and experimental activities with broader application. And this will be done in compliance with TRIPS. So TRIPS comes up the whole time. But basically, there's a recognition that a prevention on experimental and research use of a patented product is necessary. It's good. And right now, that's excluded in terms of the Act. So we need to be looking at the Act to make allowance for that, to make an exemption for research and experimental use. Okay, because right now, that's typically an act of infringement in terms of 45. Okay. Compulsory licenses and voluntary licenses, we spoke about those. So that the policy will sort of encourage voluntary efforts by IP holders to create fair and beneficial licenses to the full extent. And then they also want to increase the ability of a compulsory license. So, you know, a compulsory license is, you know, can only be granted when there's a manipulation of the South African market, or the pricing is not fair, or the needs of the country are not being met. Only then can you get a compulsory license, and then you have to have approached the patentee, and he's got to have said no, and it's got to be unreasonable. So there's a whole drama to get a compulsory license. So what they say here is South Africa's unique challenges will require the scope of compulsory licenses to be strengthened and clarified in a manner that is fair and compliant in relation to both international obligations and national law. Guidelines will be introduced following due process, including a legal process for government use and renewed effort to facilitate the process of exporting IP goods, such as medicines, to the African continent. So they're really they want to relook at the mechanism behind compulsory licenses. And I get that, you know, I mean, the fact that there hasn't been one compulsory license filed in South Africa or granted, despite there being several applications, I think that says a great deal. So, yeah. Government use, okay. Insofar as public non-commercial use of patented subject matter is concerned, Article 31B of the TRIPS agreement explicitly states that such use is not subject to the requirement of prior negotiations with an IP holder. But in South Africa, we haven't implemented that flexibility. Government use in South Africa still requires engagement with the patentee. And so precedent for implementation of this Article 31B of TRIPS, and it's that they're looking to introduce that in South Africa so that the government can, in fact, walk and take it in terms of in terms of the requirements of 31B of TRIPS, and not have to necessarily negotiate with the patent holder. So that's kind of like expropriation, kind of, do you think? I don't know. expropriation without payment. So you can see that there's a national dialogue about this, and we seem to be moving in the same direction. So, these conversations, I think, are very interesting. Okay, I think that's about it. The rest of section 7 is, a little bit, I think you should read it. It's interesting for contextualization, but it all just talks about increased harmonization of South African law with international law, and that would be substantive examination, opposition, full disclosure, utility models, increased burdens of entry for inventor step, etc., etc. And I think it's very likely that there will be an exam question on this, because it's just so important, because it talks about the IP of tomorrow, and that's your IP. The IP of today is one thing, but the direction in which we're moving as a country in terms of our IP policy and our IP legislative framework, I think it's important. It's a debate, and you need to be well versed in that debate. You need to know in which directions we're inclined and why we do so, and you need to form an opinion on whether it's a good thing or a bad thing. So on that basis, I think it likely that you will be examined on this IP policy. So just saying. Okay. Guys, that's where I want to end it today. It's just been just under 2.5 hours, and I think that's more than enough. You've been great. We covered a lot of ground today, but really I cannot emphasize the importance of what we discussed today. The IP policy, where we're going as a country, and how we look at other mechanisms to protect innovation to the proprietors of knowledge. And I'm talking particularly about the NEMBA Biodiversity Act here. These are all very, very important questions, and you really need to know your way around this stuff today. Ignore today's lecture at your peril. Okay, guys, that's it. I'm done. Before we sign off, there's one more lecture. It's 2 weeks today, the 21st of May. After that, you'll have 3 weeks. We write on the 15th. Remember, it's an in-person 6-hour open book lecture, Auckland Park campus. I'm going to be there. I'm going to be invigilating the exam. I'll make sure that nothing goes wrong in the day. I'll be there to answer any questions that you might have. I'll have some tissues with me in case you start crying when you see the exam, because it's gonna test you. The exam has been set. The exam has been moderated. It is now with the relevant authorities. The wheels are turning. So we're good to go. I know that none of you will fail this exam. You are all in possession of everything you need to do well in the exam, but that's not to say it's going to be a walk in the park. All right. I'm stretching you guys. You guys are postgraduate. This is a good degree. This is a well-regarded degree. The profession likes this degree. And there are certain standards that we uphold in this degree. You are all up there in that atmosphere. There are no exceptions. All of you will do me proud. I know it. But you guys do need to do the lectures. You guys do need to read the case law. You guys do need to be very familiar with the syllabus. I've shown you how I want your essays, how I want your opinions drafted. I hope my feedback on your assignments was useful in that regard. That's what I'm looking for going forward. As you can see, the average for the assignments, 62.5%, which is okay. 2 of you did worse than that. 2 of you did better than that, giving me that average. As I said, my course is difficult to fail, but it's also difficult to do well in. So, you guys are coming in exactly where I want you to be. Although I'd like you all to do well. You really have to demonstrate an incredible manipulation of the knowledge set, and there's a lot. Let's be honest, there's a lot. So so that's where we are. I'm very happy with where we are at the moment. It's going well. One more lecture. Next week's lecture will be designs. There will be a question in the exams on designs. Trust me. So next week's lecture is hugely important. In the 3 weeks in the run-up to the exam on the 15th of June, I, of course, will be available for another ad hoc lecture, at least one, where we can go through any aspects which you want more questions on. We can talk about exam technique. We can talk about what's going to happen on the day, any assistance that you need with your exam. So we can schedule an ad hoc lecture if you would like one in the period between the 21st of May and the 15th of June. Just reach out to me. I will make that happen. But one is not scheduled. That is, it's up to you if you want one. But I, of course, will come to the party if you do. Okay, guys. So, you know, wow, we're really nearly at the end of the course. Certainly, we finished the patterns section of it. Amazing. When you think about it, just designs to do, and we shoehorn that into one lecture in 2 weeks' time. So, yeah, until then, I will sign off. I don't know if anybody, Sally, Tabiso, Dineo, if you have any questions. Otherwise, be good. Enjoy the rest of your day, and I'll see you in 2 weeks. Okay.
Thank you, Prof.
Thanks, Sally.
Thanks, Prof.
Thanks, Tabiso. Dineo, you've got a question? You're on mute.
I just want to ask, the next week lecture is going to be online or we'll have to go physical?
No, it'll be online. It'll be online.
Okay. No, thanks.
Another one like this.
Okay.
Yeah. I'll send out the invitation in this week sometime also.
Okay.
I can tell you that we cover the whole of Dean and Dyer chapter 7. And that's a big chapter. It's it's 35 pages. So if you want to do a pre-read of Dean and Dyer chapter 7, it'll stand you in good stead. And then I'll go through it quickly over about 2 hours. I'll emphasize the bits that are important, and I'll show you how I sort of want you to manipulate that what kind of questions you can expect on designs. But have a pre-read of chapter 7. That's our departure point.
Prof,
Yeah.
Is it for next week or the 28th?
28th. I beg your pardon. 28th. Yeah. I can't do 3 weeks.
I don't know about the other guys. Can't we push it for next week? Or
next week might be a bit difficult for me. Kind of got something planned. I don't know. Dineo, how do you feel about it? Do you want to wait until the 28th, or do you want to do it before the 28th?
I really don't have a problem. Any date, I'm flexible.
Okay. Sally?
I'm okay with any day.
Okay. Tabisa, why do you say you want to push it out for 2 weeks?
the exam prep, Prof. I just want to get the lectures out of the way, but it's no problem. We can have it on the 28th. No problem, Prof.
Yeah. All right. Cool. All right. Let's shoot for the 28th. If you guys get your heads together and want to change that, I've got something scheduled for next week Saturday, so we couldn't do it on the Saturday morning, but we might be able to do it a little bit sooner if you want. But let's shoot for the 28th. Let's shoot for the 28th. That's fine. Okay. Great.
Thanks, Prof.
Thanks. Dana, all good? Your hand is still up? Are you fine?
Oh, sorry. No, sorry.
All right.
Can we remain after Prof has excused himself, please, so that we can discuss something?
No problem. Prof, one last question. I heard you saying it was a 6-hour paper. It's no longer 5.
Did I say 5?
Please let it be 6, Prof. It's 6 hours,
Do you want it
right?
to be 6 or do you want it to be 5?
6.
6, please.
6. Then it's 6. That's
Yes.
fine. 6 is fine. I'll make it 6.
Oh. Thanks, Prof.
I'll bring a good book to read, so I'm there. Okay, yeah, 6 hours. Don't worry about it. 6. Great stuff. All right. Thanks, guys. We'll talk soon. Okay, I'm going to leave. Good luck. Cheers.
Hi, guys.
Hi, Dineo.
How are you?
Hi, Dineo.
I've never questioned myself so much. What is it that I'm doing with this? We are recording. We are recording ourselves. Okay, let's excuse ourselves because this thing it's recorded and Rudo might have access to our conversations.
I think he stopped the recording.
Oh, let me just dismiss. Oh, okay. This is tough, guys. How are we going to help each other? Because I'm telling you, with trademarks, some of you made it because we had a preparation, a group discussion before, so that some sort of made things easy for us to make it. So I don't know, do you have any suggestions as to how are we going to help each other on this?
I just scored you guys an additional hour, so you see.
You just say?
I'm saying I just scored you guys an additional hour, you see.
I'm not getting you.
Linda, I don't get you, Tabiso. Please.
I'm saying, can you hear me now?
Yeah.
I'm saying I just scored you guys an additional hour, you see.
Oh, yeah. Thank you.
You
Because
got
I
us
was
an
worried
additional hour.
Yeah.
For what?
That paper was set for 5 hours.
Oh, thank you for that. Thank you for that.
So
Yeah,
it's going to end at 2:30 instead of 1:30.
Yeah, no, thank you for that. But guys, like, did you read those questions?
You're going to see flames here.
I'm not getting whether the point of departure from those questions, was it coming from the IP police or from Dean and Dyer? Because really, it seemed so strange to me, and it's all new.
Some they go to Hodia. I've seen something around those Hodia thing. I think it goes to is it the policy or is it the Dean and Dyer Tabiso?
It's the policy and what is this? That number act.
Or the number act. Or okay.
Yeah.
Oh, guys,
So
I haven't started with this IP thing. I only have 3 weeks to prepare.
So with this IP policy, I saw Prof only did section 7, right? Are we only supposed to do section 7 or the whole policy?
I think it's gonna be section 7 where he emphasized mostly.
But I think you need to familiarize yourself
with it, just so that you can know. But even though you familiarize yourself with it, but the highlights of everything, it will be 7.
Yeah, chapter 7.
Yeah.
It's really something else. I'm trying to concentrate on it, but I'm not understanding anything when I read, especially Dean and Dyer.
Yeah, hey guys.
I don't know whether it's English that is the
problem
or what.
It's not English. It's not English. Trust me.
And I didn't do well with the assignment. Yeah.
Even me, it was not really that good mark, you know.
Yeah.
When he's busy saying the average was 62, I'm like,
yeah.
Did anyone get a distinction in this?
There's no one that got a distinction. That means.
Yeah, we just have to pull our socks in this one.
The thing with the assignment, it gives you an indication of how well you'll fare in the exam.
Yeah, I think maybe
I thought Tabiso would have 80 plus with the assignment.
It didn't happen, Shem. Because with Prof last year, if you got maybe let's say in 80 for the assignment, for the test maybe or the exam, you'll get around about 60 or 70 there. Done.
Then it's a pass.
Then if you got 60, yeah. This guy marks strictly. You can see his method of marking.
He's strict.
Yeah, I think maybe it's better we touch on easy topics maybe that we understand, so that at least we could capitalize on those easy topics.
Yeah.
So can we make time maybe next week, Saturday, I don't know what time, and just so that we go through the questions and whatnot? Or must we wait until we finish the lectures? What's your take?
Maybe we should just give ourselves time, maybe that Saturday, to say from today up to that Saturday, we we get to familiarize ourselves with the content, maybe go back and start on them, and then after the second lecture, after the upcoming one,
Yes,
we
then
can
we
now
can.
organize to discuss some of these things.
That's perfect.
Because really, if I'm to come next week, I'll be like, I really don't know. Yeah,
It
I
would be
haven't
something
really absorbed
else.
myself.
Yeah.
Okay.
Guys, have you seen those cases?
I'll just
Yeah.
gonna make summary, Shem.
Can you also share the online Dean and Dyer if you have it?
Yeah, but it's a big, I don't know how am I going to share it. I'll check Rudo's email because it was big last time. I don't know how I made it, but I'll try and check it.
Oh, okay. Did she send to everyone?
She just sent it to me. Maybe you can just email her.
Okay, no problem.
Yeah, yeah, 'cause I need to buy the book. It looks like the online one is not complete. I need to buy a book next week.
Yeah.
I do have some of the chapters, hence then I realized last week that the book is not complete. That means I need to buy a book.
Yeah. We have a long way to go.
Oh, guys. Oh, if we pass this one, it will be grace.
And time is of the essence.
Yeah, true that.
We don't have any much time left, eh?
Time. Shoo. Okay, guys. I just wanted to ask, how are we going to assist it? It looks like it's clear. Let's go have a rest and then maybe study later.
Yeah, thanks for the chat.
Okay.
All right, sure.
Okay, bye.
Chap.